Pennsylvania froze my bank account. Here's what actually happened and how to stop it. You went to pay for groceries or gas or your electric bill online and your card got declined. You checked your bank account and the money is gone, not spent, not transferred, frozen, locked, inaccessible, and you have no idea what just happened. What happened is called a bank levy, and unlike what most people assume, it wasn't your wages that got taken, because here in Pennsylvania, creditors generally cannot garnish your paycheck the way they can in most other states. Pennsylvania actually has stronger wage protections than nearly anywhere in the country. But your bank account, that's a different story entirely. Hi, I'm Sean Quinlan, and today I'm going to explain exactly how a bank levy works, why it can happen faster and harder than you expect, and what legal tool can stop it and potentially undo it. Pennsylvania and wage garnishment, the truth. Let me start by clearing up one of the most common misconceptions I run into as a bankruptcy attorney in Pennsylvania. People come into my office terrified about wage garnishment. They've been threatened by collectors, they've read things online, and they're convinced their employer is about to start sending part of their paycheck directly to a creditor. For most consumer debts in Pennsylvania, credit cards, medical bills, personal loans, that fear is actually unfounded. Pennsylvania law does not allow wage garnishment for most civil judgment debts. Your paycheck, in most circumstances, is legally protected. But collectors know this, and they have another tool that is just as powerful, arguably more so, and most people have no idea it's coming until it's already happened. What a bank levy actually is. A bank levy is a court-authorized seizure of funds directly from your bank account. Here's how it works. A creditor sues you. You either don't respond, can't respond, or lose the case. The court enters a judgment in their favor. The creditor then takes that judgment to your bank. The bank is legally required to freeze your account up to the amount of the judgment and hand those funds over to the creditor. This happens without any additional warning to you. No phone call, no letter, no grace period. You find out when your card stops working or when you log into your account and see a zero balance. The timing is also brutal. In Pennsylvania, once a judgment is entered, the creditor can move to levy your bank account relatively quickly. And unlike wage garnishment, which comes out gradually, paycheck by paycheck, a bank levy can wipe out everything in your account in a single action. If you had $2,000 saved for rent, it can be gone in an instant. What funds are protected from a bank levy? Here's where Pennsylvania law gives you some protection, but you have to know the rules to use them. Certain types of funds deposited in your bank account are protected from levy even after a judgment. Social Security benefits are federally protected. A creditor cannot levy funds that can be identified as Social Security deposits. The same applies to disability benefits, veterans benefits, and most federal benefit payments. Unemployment compensation in Pennsylvania is also protected. The critical word there is identified. Banks are required to conduct a look-back analysis, typically covering the prior 2 months, to identify protected federal benefit deposits and exempt that amount automatically. But this process isn't perfect. If your protected funds have been mixed with other deposits, or if the bank makes an error, you may still see your account frozen and have to fight to get it released. How fast can this happen? Faster than people realize. Many debt collection lawsuits go undefended because the debtor never received proper notice, didn't understand the legal process, or simply hoped it would go away. When a lawsuit goes undefended, the creditor gets what's called a default judgment, and they can get it quickly. From there, the levy process can move in a matter of weeks. This is why I tell people, the moment you receive any legal paperwork from a creditor, any lawsuit, any summons, treat it like a house fire. Don't set it aside. Don't wait to see what happens, because what happens, if you do nothing, is a judgment. And what follows a judgment in Pennsylvania is very likely a bank levy, the tool that stops it and can reverse it. Now, here's what I need you to understand. If your account has already been levied, or if you know a judgment exists and you're worried a levy is coming, filing for bankruptcy, Chapter 7 or Chapter 13, triggers what federal law calls the automatic stay. Under 11 U.S.C. Section 362, the moment your bankruptcy petition is filed with the federal court, all collection activity must stop. That includes any pending levy actions. It includes any freeze on your bank account that hasn't yet been transferred to the creditor. If the levy hasn't been fully executed, meaning the funds haven't yet been turned over, bankruptcy can halt it mid-process. Chapter 7 versus Chapter 13 in this context. If your primary goal is to stop a levy or prevent one from happening, both chapters of bankruptcy give you the same immediate protection. The automatic stay kicks in regardless of which chapter you file. The difference matters for what comes after. Chapter 7 is faster, typically resolved in 4 to 6 months, and eliminates most unsecured debt entirely. If you qualify based on the Pennsylvania means test, it is often the simpler and more complete solution for someone dealing with credit card or medical debt that led to the judgment. The exemptions that protect your property. I want to address the fear that stops most people from calling a bankruptcy attorney, the belief that if they file, they'll lose everything. For the overwhelming majority of people dealing with a bank levy situation in Pennsylvania, that fear is simply not accurate. Pennsylvania and federal bankruptcy exemptions protect your retirement accounts, 401ks, IRAs, pensions, almost entirely. They protect your home equity up to the applicable exemption amount. They protect your vehicle up to a certain value. They protect your household goods, your tools for work, your clothing. They protect Social Security income, disability income, and other benefit payments. What you should do right now. If you have a judgment against you in Pennsylvania and you still have money in a bank account, here is my honest advice. Do not wait. A levy can happen without warning. Every day that judgment sits there is a day the creditor can move on your account. If your account has already been levied, call a bankruptcy attorney today. Not to think about it, not to research it more online. Today. Move closer to camera. Slower. This is the moment. I am a Pennsylvania bankruptcy attorney, and I want to be very direct with you. If you are watching this video because something has already gone wrong, your account is frozen, your balance is gone, you just found out a judgment exists, please call my office today. The consultation is free, the conversation is confidential, and in one phone call, I can tell you exactly where you stand, what can be stopped, what might be recoverable, and what your life looks like on the other side of this. That number and the scheduling link are right below this video. Please don't wait another day. Like, comment, subscribe for more Pennsylvania bankruptcy and debt defense guidance.